Okay, so New York Lawyers for the Public Interest is a nonprofit legal organization. We provide free legal services. We don't charge anything for any of our services. All our services are provided to you for free. We take individual cases, but we also do what is called systematic cases, class action, in which we take cases that have a common trend, and then we realize it's a system that needs to be changed. And when that happens, those are systematic cases that we work on. And we also, they also call it class action cases. I want to remind everyone that if you need to contact us, if you have an issue, a concern, a legal issue, our telephone number is 212-244-4664. Our intake hours, meaning the hours in which somebody's gonna pick up the phone and gather your information, is from 10 to 3. Easier these days, if you have a smartphone, you don't even need to call us. You can click nylpi.org/get-help, and you will only fill out 3 things: your name, your telephone number, so we can contact you, and the issue that you are calling about, education, housing, whatever that is, you will put it there. Our mission is to work to advance equality and civil rights with a focus on disability rights, health justice, and environmental justice. I work under the Disability Justice Program. We have been doing this work on behalf of people with disabilities for over 40 years, actually closer to 45 years. So we are well known as being one of the few legal organizations that do disability rights. I'm gonna go in great detail because this presentation is very long, and I'm gonna be very fast because I want to address every single point that I'm supposed to be presenting here today. But if you want to learn more about New York Lawyers, feel free to check our website at nylpi.org. We have a lot of information there. In terms of this particular presentation, this PowerPoint, I'll be happy to share the PowerPoint with anyone. Just keep in mind that this is intellectual property of New York Lawyers for the Public Interest. What that means is you're able to share with others, but you cannot alter any information in this presentation. You can not divide it, you're gonna break it down. If you're gonna share it with someone, it has to be a complete product because we own the PowerPoint. That's what intellectual property means. Our biggest program, the Disability Justice Program, it focuses on education, community integration, opportunity and access, and community access. Once again, to learn more about our other programs, feel free to go to our website and you will get a host of information there. Okay, my agenda today. So we're gonna talk about special education, IDEA, which is the law, and the free appropriate public education, special education during remote learning, which is now some of your students have gone back to school. High school went back last week or this week, I forgot already. But if you have a child that is still learning from home because you decide to keep your child at home, your child is still going to remote learning. We're gonna talk about the special education process, identification, referral, evaluation, eligibility determination, IEP, and placement. That's actually the process. Most of you probably have gone through this process. I just gonna explain really how it happens for those individuals who are like newcomers in terms of new to the system of special education, or people who are already in the system and then didn't realize that is actually a way to get there where they at. And then I'm gonna talk about corporal punishment and physical abuse, and this is related to Chancellor's regulations, and this have to do with punishment and abuse from a staff to a student. Due process rights, which includes mediation, partial hearing, and pendency. I'm gonna talk about charter schools a little bit. 504 plans, and private schools. So it's very, very, very a long agenda. So I'm gonna go right into it. And what is a special education? So a special education is a specialized instruction and related services individually designed to provide an educational benefit. A special education is not a place, and we have to be clear about that. What that means is that if your child have a diagnosis of autism, doesn't mean that he could only attend schools that educate kids with autism. It depends the work that needs to be done, if to evaluate to see what he or she their needs are, and therefore look for a placement that is appropriate. So a placement could be community school, it could be a specialized school, it could be charter school, it depends. It could be District 75. So once again, it's not a place, it's a specialized instruction and related services individually designed to provide an educational benefit. And we have to be clear about that. What is IDEA? So this is the law. So a federal law that protects children's rights to a free, appropriate public education, which is called FAPE for short. So almost on every single advocacy that we do, we invoke FAPE, and a free and appropriate public education. And also part of the law is mandating that kids, when appropriate, will be educated in the least restricted environment. So when we are talking about special education, we are looking at those two things, that the education is appropriate and also in the least restrictive environment. So FAPE means that it's free to public, means free. You don't want to pay for that education. That's what free means. Appropriate means appropriate for your child. And this is very important. You as a parent, grandparent, family member advocating for your child with special needs. When we talk about appropriate, when we are discussing an IEP with the support team, we're talking about appropriate. And I want you to be clear, because for most parents, and I raise my hand too, we want the best education for our children. However, legally, what the Department of Education law says, right, that the law says is an appropriate education. So we have to make that distinction when we advocating for our kids. Public means under the direction of New York City Department of Education. And your children could receive this education from preschool all the way to 12th grade, and also up to the age of 21 years old when appropriate, meaning that if your child is not ready to graduate at 18, 19, they could stay in school until 21. Okay, who is a child with a disability? So under IDEA, they specifically lay out who is a child with a disability. So a child with a disability is a child who is classified, and I want to make the distinction. This is not a diagnosis, this is a classification. Now, there is confusion here for families sometimes because, for example, in the case of autism, there is a diagnosis, but it's also a classification. But when we're talking about special education, we're talking about IDEA and classifications. So on the IEP first page, you're gonna see always a classification, and that classification has to be one of these: intellectual disability, hearing impairment, speech or language, visual impairment, emotional disturbance, orthopedic impairments, autism, TBI, traumatic brain injury, other health impairments, and a specific learning disability, deaf and blindness, deafness, and multiple disabilities. So out of when you have your child evaluated and you go to that IEP, and this question comes about for many, many families to me, like, my child is diagnosed with 5 different things. So what happened is, in that process, what is gonna put on, is supposed to be on your IEP as a classification, is the classification that at the time of evaluation is interfering with your child's education. So, and I'm gonna give you an example. There are kids, for example, that when they start, the first IEP will say autism. That's what really is interfering with their education. As they grow, especially I see this a lot, higher middle school to high school classification sometimes change to ED, emotional disturbance, because sometimes in the process of maturing and when they become adolescents in that process, then their behavior start increasing, and therefore what start interfering with the education is their behaviors, and therefore the classification gets changed from autism to ED. That doesn't mean that they don't have autism anymore. They do, but the classification that is most appropriate for many, many cases is ED, because their behaviors is what is interfering with their education. And we have to be clear about that. And we have to ask those questions. If you are in a meeting, an IEP meeting, and the team is telling you, oh, I think it's most appropriate to change your classification due to your child's change on behaviors, you need to ask those questions. What happened here? A diagnosis may not be enough. We have to be clear about that. And I always talk to the parents about getting independent evaluations. Evaluations done by New York City Department of Education and most any education department in the United States are geared to draft an IEP, is geared to education. Now, you want to learn more about your child's challenges and disabilities. And that usually is through an independent evaluation, either an neurological evaluation or any other evaluation and that will provide you with more information about your child. And it is very important, because then you will know more about your child and you can add more to those conversations when you are meeting with the team at school. Classification, once again, does not determine placement. Placement must be determined by the needs of your child, not by the classification. Once again, because your child, if classified with autism, doesn't mean that he only is able to go to a school that teaches kids with autism. It could be that your child could function in a community school with services, in a small class of 12s or an integrating co-teaching. Once again, this is about what is appropriate for your child. Students are served according to need, not to classification. We have to be clear about that. And once again, the goal here is FAPE, free and appropriate public education in the least restrictive environment. So we have to at least at minimum understand those concepts. Okay, who's entitled to a special education? A student has a disability and requires special modified instruction. This is important because when we think about IEPs and students with disabilities, many times we think about a student who have cognitive limitations, not necessarily. Students with physical disabilities, students who uses a wheelchair may have a modified instruction, and also students what we call sometimes invisible disabilities, students who are going through depression, students who are going through anxiety, bipolar disorder, and students with ADHD would happen to have a lot of them in the system. So once again, when we're talking about students that will need accommodations or an IEP, we're not only focusing on students who have cognitive limitations, we're also focusing on students that will need some accommodations in order for them to benefit from their education. What's going on now during COVID-19? So we are actually trying to walk through around the COVID-19. I think that because of the vaccine, many things are going back to normal in quotes. However, I think the most important thing for you to understand is during this period of time, if your child have an IEP, if your child have a 504 plan, that's still remains, like nothing changed. Of course, we need to accommodate in terms of, things are different now, but if your child needs services, if your child needs, those things need to happen for your child. If your child is not receiving services, something's going on, you need to call the school and you need to request information about what's going on with those services. Now, services that were not provided for your child during the pandemic because people they didn't have enough people providing services and all that, you should be able to recover those services. And once again, if your child was entitled to 3 times a speech therapy and those because of the pandemic were not provided, definitely you should ask for it, and they should accommodate your child and try to include the extra time to provide those services, or provide you with a list of providers that will provide those services at after school of a different time. But once again, whatever is your child is entitled during on their IEP, they supposed to have, that have not changed. And this is the same. This is the same that I just talked about that. Okay, so I'm gonna jump into the process of special education because I don't know who's the audience here. We may have people who their kids is about to graduate, or we could have people who their child is in kindergarten and just find out that they might need an IEP or just started with their new IEP. So the process is clear and it starts with identification. What that means is, for example, if you realize or you notice that something is going on with your child, you cannot put your finger on, and your child is already, let's say, first grade, kindergarten, first and second, and he's always behind, he is not able to grasp concept, your child didn't attend early intervention, or you didn't know anything about special education, you can ask the school to see if they could evaluate to identify. Or many times, the teachers at the school, the people who are working with your child, suggest to you that perhaps your child needs to be evaluated because they have identified certain things that are happening with your child during the day at school. So it could go either way. It could be you asking for an evaluation to identify, or it could be the school. Many of you already have come with identification because your child have attended early intervention, especially preschool. So, the flow will be that kindergarten will, that will continue. But for many families, the identification comes like first grade, second grade, third grade. Then you will receive what is called a referral consent, meaning that if you agree that perhaps the child should be evaluated, then the school will send you a referral consent, meaning that you are agreeing for your child to be evaluated. Then it comes the evaluation process, in which the Department of Education will do what is called a psychoeducational evaluation, in which they will evaluate your child to see if your child needs some supports. And then the next step is eligibility determination, meaning that not every child who is evaluated will be eligible for services. So in the process of evaluating, then this piece that is eligibility determination, meaning that, okay, we're gonna look and we're gonna evaluate and we're gonna see if the child is eligible for services. Then it comes, if the child is eligible for services, then it comes the IEP development, in which is that meeting that you will sit in a room with different people, the teacher, the psychologist, or the social worker, or both. Sometimes if the principal of the school is also the a rep, so he will sit there also, and then they will discuss with you the child's needs in order to draft an IEP. Now, keep in mind that you are part of the IEP, meaning that you have things to add to that meeting, and you should make your voice count about what you see that your child needs in that meeting. Doesn't mean that you're gonna get it, but it means that you also are an active participant of this meeting. Then it comes placements and service. So in the case, for example, if your child is evaluated and is determined that your child, for example, is sitting right now at the time of evaluation in a regular classroom, general classroom, but after evaluation, it will be determined that your child needs a smaller classroom, like a 12-1-1, 12 student, one teacher, and one paraprofessional. And let's say if the current school doesn't have that setting, they're gonna have to find you a school that is able to accommodate your child's IEP. So in many cases, when the IEP is developed, then many of the students will need to move schools to accommodate their IEP if the current school doesn't have what your child needs. Once again, a reminder that the parent and or legal guardian is an important part of the IEP. You know your child better than anyone else. You work with your child every day. So you're definitely able to add where you think it works for your child. And you should express that this is the time, this is the moment, because usually these IEPs will last 1 year. It doesn't have to, and I'm gonna explain, but whatever is agreed upon in this meeting is gonna be for the entire year. So you make sure that you participate in that meeting to add what your child's methods of learning, how he does homework, all that is important information. Also, if by the time of the IEP, you have independent evaluations that have provided more information about your child, please share this information with the team. This is important for you to do at least a week before the IEP meeting so they could read it. Don't wait until the IEP meeting and then bring those independent evaluations, because they're not gonna have time to read it. Same way for the IEP. If they evaluated your child, if they did a psychoeducational evaluation, if they did a speech and language evaluation, they did an occupational evaluation, all those results need to get to you at least 5 business days before the IEP meeting. Why that is important? Because you need to understand their findings, so you need to also be prepared with questions if you don't understand something or you're in disagreement with the findings. So it's important for you to get that information as soon as possible. As a matter of fact, if the IEP is approaching and you don't get that information, you are entitled to change the date of the IEP because you have no information about the results of the evaluations that they're going to be discussing. So that's important for you to know as well. The other people that are going to be participating is your child. And when we say your child is when is appropriate, that means that kids who are older, 14, 15, 16, when they're able to add what they want and what works for them, we always want that student in the room. The school-based team, support team, like I said, teachers, psychologists, occupational therapists, speech and language, all those individuals should be there in case that they're not able to be there because they're in class or they're providing therapies. They're supposed to send a report about their recommendations. The district level rep, once again, sometimes somebody in the school is also a district level rep. If it's the principal, then the principal will attend as the district level representative. Or anyone else. Sometimes the psychologist, the district level, sometimes the AP, someone will identify themselves as and the principal, but also the district rep. And then the committee on special education. These are for students who are attending a non-public and charter schools, as well as students on home instruction. So when you see somebody from CSE, it's because your child is attending charter or is in a non-public school or in home instruction. Okay, so we also need to understand the systems where the child receives special education. So there is the public system, which are community schools. Then is District 75, specialized district. And there is District 79, which is the district for alternative schools and programs. Then we have charter schools. And let me remind everyone that charter schools are public schools. However, the way that they operate is a little bit different. And we have the non-public schools, that what most people call them private schools. We call it non-public because there is like several ways to get to a non-public school. And one of the ways is Central Day Support Team, which is the schools who are approved by New York State. What that means, an approved school, what that means is that there are some private schools that have contracts with Department of Education for payment. So what that means. And then there is the private, what we call the private schools, which are those schools who do not have contracts with New York City Department of Education. So we need to be clear when we talk about the different schools, what we're talking about. Okay, so evaluations. So DOE is required to evaluate your child every 3 years via doing a psychoeducational evaluation. However, I want to make clear here that if your child's current IEP is not working, if your child is not making enough progress, if your child is having a lot of issues and he or she is not due for another evaluation, it doesn't matter. You can always ask and request the Department of Education to reevaluate before those 3 years. Because remember, the point here is for your child to make academic progress. So if something is not working, let's say they draft an IEP last year based on an evaluation that it was done 2 years ago, and this IEP is not working for whatever reason, and you want to call a new IEP, you can also request for a new evaluation. You don't have to wait 3 years. You can also request different types of evaluations. For example, you can request a new speech evaluation, a new occupational evaluation, a new assisted technology evaluation. So it doesn't necessarily have to be a new psychoeducational. It could be any of the other evaluations that DOE does, because whatever is going on currently is not working for your child. Once an evaluation is requested, DOE have 30 school days to complete that evaluation. This is important because when families call me, I ask them, when do you request that evaluation? Oh, I don't remember. Well, you have to remember because DOE have 30 days to complete it. So if you requested last week and you call me today, you're too early. They might be working on figuring out who's gonna evaluate. So the date that you request is very important. Also, I'll give you a tip. When you request an evaluation, do it in writing. It doesn't have to be a formal letter, but now everyone is using email. Email it to the principal, email it to the team, say I'm requesting new evaluations because things have changed with my child and I want to know what's going on. Whatever simple language you want to use, because that also is gonna serve you as the day that you requested, because DOE have 30 school days to complete the evaluation.
And after, quick question, just to clarify, just because this is so important, you're right. When we're talking about school days, we're talking about business days, right? That means Monday through Friday, or?
No, we're talking about school days. It's very specific. When we're talking about school days, are the days that school are opening, like through the school calendar. For example, if you ask for an evaluation on December 15, we all know that school closes during Christmas. They have like certain 1 or 2 weeks or 10 days that they close. So that doesn't count. Those 10 days don't count because there is nobody at school. So that's why it's very specific to school days. If you ask for an evaluation December 15, you need to count the school days for the rest of that month and in January in order for them to complete all this.
Perfect. Yeah, because
Okay.
it's never clear enough. And I can't tell you how many times parents always ask, does that mean calendar days? Does that mean business
School days. It's
like,
school days. And if we think about it, right? Because the people who are going to evaluate your child is usually school people who are in school, the psychologists, or even at the central base, right? If the school is closed, it's no, the people who actually know your child, they're not there. So it makes no sense for anyone else to evaluate. Now, keep in mind that sometimes kids are evaluated during summer just because something have changed and they need to have an NYLPI by September when school starts. That's different. This is still the 30 days it legally applies, but sometimes the OE accommodate families due to the fact that the kids something have changed. I have, actually done those cases in which we need something during the summer because whatever was happening before the school closed, it wasn't working, and we need to put together an IP that is going to work starting the new school year. So once again, it's school days, not business days. Okay, once the initial evaluations are completed, DOE must convene for an IEP meeting. So follow the evaluation, you must convene for an IEP meeting. There is no such a thing like you do an evaluation, they create an IEP and you don't know about it. Absolutely no. Once an evaluation is done, you're supposed to get a notification for an IEP in which you able to participate in person or over the phone or via Zoom, whatever medium they're using. But once again, after the evaluation is done, then it comes the IEP. After the IEP is set up, meaning that you meet, you talk about the IEP, they modify the IEP, then DOE have 30 days to implement that IEP. Once again, 30 school days to implement the IEP. If you have an IEP, once again, December 15, but the school is gonna be closed, nobody's gonna be working on implement that IEP until the 30 days, up to the 30 school days that they're supposed to. So we have to be clear about that. Dates are very important in terms of evaluation, IEP implementation.
Absolutely. And one quick question, because we have a parent, Miss Ibarra, who asked a question, and she was saying that she's requested her new evaluations for her son's IEP meeting, but they never share them before the meeting. And they say that they're not obligated to send her that information before. Is that true?
That's wrong. That's wrong. They're obligated to send the information at least 5 days before the IEP. The evaluation must be shared with families 5 days before the IEP. There is an obligation there. How can you discuss the findings of that evaluation if you have no idea what they found?
And do you know around if a document needs to be, an evaluation needs to be interpreted or translated rather, does that have to be done within before the 5 days before the first IEP meeting?
If the family needs a document that is translated in a different language, you need to request that at the time that you request an evaluation. So they know for sure that that document needs to be translated. Now, most important here is that somebody, even if they don't give you the translated document, somebody needs to talk to you about that document in your own language. And I say this because it seems to be that the OE struggle a lot with translations. And my own experience has been as a person who is an interpreter and translator, at least for Spanish, when they translate documents, I cannot even understand what the documents say just because they use Google Translate. They don't use someone, they use a tool. So that means that sometimes the information is really irrelevant, because if I cannot understand it in my own language, somebody needs to explain it to me. So once again, if you need documents explained to you, that needs to happen before the IEP. You need to be armed with that information before the IEP, and you're entitled to that. You're entitled to ask for documents to be translated into your own language. DOE have, I think, I don't know, 10 or 13 mandated languages. I think it's in their website that you can look up to see if your language is one of them. And then they're supposed to translate that information. Now, what you cannot do is to not say anything that you need those services, and then the day of the IEP demand that somebody interpret for you, because that's not going to happen. I mean, if you speak Bengali, what are the opportunities that somebody's going to know what's in that evaluation, and they provide that information for you on the spot the same day? That is not appropriate. If you need translation services, interpretation services, you are entitled to those, but you need to request them ahead of time. Now, what you're able to do is that if you request it ahead of time on the day of the IEP, they don't have that service, you are entitled to say, I cannot have this IEP meeting because I requested an interpreter and the interpreter is not here, so I cannot move forward because I don't understand. That you can do. Okay, so the IEP is a legal document. We have to be aware of that. The IEP is a legal document that discusses your child's educational needs and the services that they are entitled to receiving. So because it's a legal document, that means it must be enforced. The IEP includes disability classification, which I talked about in the beginning, includes classroom size and setting. That means general education, integrated co-teaching, 12 one-to-one, 8 1-to-1, 6 1-to-1. All that is included on the IEP. Also includes educational supports, related services, and accommodations, meaning if your child needs occupational therapy, speech therapy, assistive technology, a paraprofessional, all that must be spelled out on the IEP. It also includes the goals and objectives. And this part, parents need to pay attention, because every IEP will lay out goals for the year. You need to ask about those goals. They're supposed to give you updates about the goals. Usually the IEP will say, after 3 attempts, the child should reach their goal. Or the goal is by the end of the year, the child should be able to hold their spoon on their own. So you need to continue following up with that. The child is reaching the goals, because this is what happens most of the time. And I do understand this. This is not a judgment call, because we're all busy, overwhelmed. We have families that have more than one child with a disability. It's difficult to keep up. But what happened is that at the end of the year, the child doesn't meet the goal, and then the parent is upset. But my child didn't meet the goal, but it's already a year later. So you need to keep, as much as you can, checking those goals and checking progress, so you can have those conversations with the teacher about how can you help, or how the things that they could implement in order to help your child to reach those goals. The IEP is reviewed and updated annually. But once again, if you have an IEP, for example, your IEP was in January, and now we are in May, and you see that your child is struggling, your child is not, keeping up with the goals, the child is having difficulties, you're entitled to ask for a meeting for a new IEP. You don't have to wait for the next January. You can, ask for an IEP to see what's going on with your child. Now, usually I suggest once again, for you to get outside evaluations to see if something has changed, if there are other things that, you know, the outside evaluator finds out that it could help you on this IEP to modify an IEP so your child could actually make academic progress. Once again, the parent and the legal guardian is a member of the IEP team. Remember that. You are the best advocate for your child. Once you go to an IEP meeting, they always ask you to sign. This doesn't mean that you're accepting what is on the IEP. What that means is you attended the IEP. That's all. So don't be afraid to sign. You're not signing on everything that is on the IEP, especially for those families who are not in agreement with what was on the IEP. The signature just means that you attended the IEP. And we're gonna talk about, when you're not in an agreement with the IEP, what the things that you can do about it.
Well, one thing, there's a question here from Ms. Zumaya. Are there any max amount of times that an IEP can be modified?
Well, this is a very important question because you only want to modify an IEP if there are specific changes, something that changed dramatically. Because at the same time, you need to give time to an IEP to be implemented. So if I have an IEP in January, and then in February, I call for another IEP, and then in March, I want another IEP, I'm not providing enough time for the IEP to be implemented. So once again, it's a balance act. If you have an IEP long enough and you realize that things are not working, of course, call for another IEP, but try to get new information. Because if you try to sit on an IEP and you have the same information that you have last year, most likely nothing's gonna change. So once again, once we asking for modifying IEP, it's because we have once gathered information that is valuable and something has changed, that it's valuable to have another IEP. But be cautious, because you have to give people time, the school time, to implement the IEP and see what is working, what is not for your child. I have parents starting in September with an IEP, and then in October, they want to change, the IEP. Why? Especially when you start school in September, there's so many off days that I doubt that any IEP is implemented properly in September. So you have to give it time. Once again, it's a call that you need to make in terms of, if the IEP is an IEP that the meeting was in March and it wasn't working in March, and we're now in September, of course, try to gather new information or a reevaluation to see their findings so they could draft an IEP that is appropriate for your child. But once again, it's case by case, and be careful about that. Okay, what should I do if the school is always calling me regarding my child's behavior? This is a question that parents ask me all the time. I have parents who the child have behavioral issues and the school is always calling. First of all, the school needs to have those conversations with you. And there's something called a functional behavioral assessment, meaning this is an assessment, as the word says, to determine what's causing those behaviors. Determine when the student engages in those behaviors, how those behaviors are impeding their learning, involve direct observation, meaning someone is going to sit in the classroom and observe your child. This functional behavioral assessment requires your consent, and you will have 10 days after the consent is sent home to sign it. And the sole purpose of the functional behavioral assessment, once again, is to see what's going on with your child during the day, during the classroom, so they could develop what is called a behavioral intervention plan, which is a plan that is going to be drafted to deal with your child's behaviors at school. And that's really what DOE needs to be doing. Instead of calling you and complaining, they should start a functional behavioral assessment to draft a behavioral plan to see how they can work with your child at school. Now, you can also request a functional behavioral assessment and a plan to see that's really the first step. Now, it may be that at the end, they draft all this and still your child is manifesting severe behaviors. It may be that then at that point, that school is not appropriate, that class size is not appropriate. It may be that your child needs medication. No parent wants to hear about this. Once again, I'm not one to tell anyone to put their child on medication or not. That's not my place. However, there are many kids, in order to be functional, they need some type of medication. That's for you to decide. But once again, you need to look realistically about the benefits, the pros and cons of medication and the child behavior in the classroom. That's for you to decide, not for me, for you to decide, and definitely balancing what's going on. Because if you have a child, for example, who doesn't focus and all throughout the day, they looking up and down and through the window, we have kids with ADHD or with ADD, then if they're not focusing, they're not paying attention, they're not going to benefit for that day, no matter what the teacher does. So once again, you need to talk and look into a functional behavioral assessment, but you also need to look about what other things, other supports your child may need in order to focus during the school day. What should I do if my child continues to be suspended? Okay, so we don't do suspensions in my office. So I'm gonna talk briefly about this, and mainly for you to understand your rights. Number one, students with disabilities can be suspended. They are able to be suspended. Having a disability doesn't rule them out of suspension. So we need to be clear about that. However, they cannot be punished for actions that are related to their disability. So we have to be clear about these 2 points. Yes, a student with disabilities, they're able to be suspended. However, they cannot be punished for actions that are related to their disability. Now, if your child is up for suspensions, DOE must follow a process. There are different types of suspensions, and there's process to it. New York Lawyers does not represent anyone with suspensions. However, if this is your case and you don't have anywhere to go, you can call us and we can provide you with different agencies that they, like Brooklyn's Defenders, I think Advocates for Children's, that they do have a staff that work on suspensions. They're very equipped to help you with that. But here's the information in case that you want to read more about it, if that is your situation. So I'm gonna skip all the suspension slides, but if you have the PowerPoint, you can definitely read about it. So I'm gonna jump right into corporal punishment and physical abuse. Once again, this is as per Chancellor's regulations, and this has to do as staff to student. When I'm talking here, it's a staff, DOE staff members to students, corporal punishment and physical abuse. I'm not talking about a student on a student. That's a different Chancellor's regulation. I'm talking about from a staff to a student. So any act of physical force on a student for the purpose of punishment is considered corporal punishment. It does not include reasonable force. And when we talk about reasonable force, we're talking about, for example, is the student is gonna leave the school and open the front door and a staff member jump and try to grab the student to prevent that student from leaving the school, that may be considered reasonable force. The staff didn't try to attack the student. The staff was trying to protect the student from leaving, you know, the school, because due to the disabilities, we have a lot of kids that actually walk away from classroom or walk away from the school. So that's what they mean. And you know, reasonable force means to protect oneself, to protect the students, to protect employees or school property. That's all. DOE prohibits the use of corporal punishment on school property, trips, school functions, and in certain cases of property if it represents a danger for the school community. So we have a lot of kids who have been abused by staff, and that's why, you know, DOE have some regulations about it. However, if that is your case, if you have a student who was punished and was physical or have corporal punishment or physical abuse, you can call our agency. We do work on those cases. Once again, we will assess the case to see if the force use was reasonable or was with the intent to punish or to abuse the student. So once again, for those cases, yes, we do, you can call us New York lawyers. Okay. Also, the OE have a report way. Once your child, something happens, an incident happened at school, you can report it to the principal of the school, to staff at school. Once again, keep notes, keep emails, keep everything. That's evidence that you report the abuse. The actually Department of Education have a specific office that is called the Office of Special Investigations that's supposed to investigate the cases. You can contact the Office Special Investigations calling 311 or 311 is the best way, by the way. So, but once again, that doesn't mean that you can call us either. So you can call and report the abuse, but you can also call your lawyers if you feel that you need that kind of assistance. But there are different types of investigations. Sometimes when you call 311, then the principal of the school will get a notification. Then the Office of Special Investigation will decide whether they're gonna investigate or they're gonna assign the school to investigate. I have to say, and to be honest, that sometimes the investigations from the Department of Education fail to communicate properly to parents about what's going on with the investigation. But once again, if this is rings your bell and you want more information about this, or you want support, or you want to talk to us, New York lawyers, about it, we're more than happy to take your call regarding that.
Paula, before we keep going, maybe we should take a break, but quick question. One of the questions Ms. Rosero was asking in the chat was, at what is the age of a child where you can do an FBA?
At any time.
At any age?
Functional behavior assessment doesn't have an age limit. You can do for a child that, you know, because the first, for most, the individuals who are gonna notice that behaviors are interfering with education are the people in the classroom. The teacher, the assistants, the people who are working with your child, they're gonna notice that your child is failing to sit down, is failing to pay attention. So they might realize that something going on. So you can request a functional behavioral assessment at any time if that is an issue. Also, they might, if your child doesn't have an IEP, they might request for an identification, like in the beginning, like I talk about identification of that process. They might talk to you about identifying your child. Perhaps your child may have a disability that you haven't realized it. And I say this because I have a lot of families that this is the first child, so they don't have anything to compare. And many families think that about some behaviors are normal because they don't have other kids. Now, when you have 2 or 3 kids and you realize that certain behaviors at a certain age are not appropriate for their age, maybe something comes and said, perhaps I should ask for an identification or talk to the teacher because my child number 3 is not behaving like the others. So once again, there's a lot of flags here that you can use. But once again, to answer the question, there is not age for functional behavioral assessment or a plan.
Wow. Okay. I didn't know that. So I learned something new.
Mm-hmm.
So let's just take a pause, everybody, to check your emails and check your text messages, get another cup of coffee, maybe your third, and we'll come back here in about 11:40, 11:40,
Okay,
4 minutes.
4 minutes.
All right.
Okay, sounds
We'll
good.
see you in a bit.
Thank you. If you discuss, oh, because I think or I want or I feel that my child will benefit from more speech, I can assure you that's gonna go nowhere most times. So, however, if you have an IEP meeting and they continue with the same amount of speech therapy, and you strongly believe that your child needs more, then go get an independent evaluation that you can talk about it, and even request a mediation to talk about, if they're not listening to you, to talk about that. But if you come with nothing, most likely you're going to end up with nothing. Okay, so I want to be clear about that. Participation in mediation is voluntary for all parties. That means that when you request mediation, doesn't mean that Department of Education is obligated to attend. They don't have to. Requesting mediation does not keep you from asking for impartial hearing later. So for those of you that have multiple issues that you're not happy with, there are some issues that you can resolve via mediation, and other issues that only will be resolved by impartial hearing. So you can do both. And the information that whatever happens during mediation doesn't, DOE cannot share with an impartial hearing. So because mediation is confidential. Now, I also want to remind everyone that mediation is not DOE who is staff mediation. Mediation, the individuals who do mediations are independent nonprofits. So they have a grant to do mediation. So they have nothing to do with Department of Education. So that's why it's another reason why you should be utilizing mediation, because it has nothing to do with Department of Education. The way that it works is literally you will request, I'm going to show you the different numbers and address in each borough. You can call them or you can request via email for mediation. They will take your information and they will, you will spell out the issues that you want to discuss. They will contact, that agency will contact Department of Education. If Department of Education agrees to meet with the mediator, then it was going to be you, the mediator, that have nothing to do with Department of Education's independent person, and Department of Education, and then you can discuss your issues. Sometimes when we get involved, I attend mediation with the family, and I have to tell you right now that most of the time I let the parent talk. I let the parent do the talking about why they feel that they want to modify an IEP or add or take away things on the IEP. But once again, you have to have proof. You have to have basis to modifying things on the IEP. That's very important. Mediators are neutral. Once again, they don't work for DOE, they don't work for you, they're independent nonprofit. Once a mediation is said and done, and let's say the representative from DOE agrees to, in the best scenario, to add more speech to the IEP, they will sign a contract, you will sign, and then the school support team must immediately meet to update the IEP to add the new session of speech as agreed to via mediation. Okay, and you don't need an attorney for mediation. It's a process that is parent friendly, is easier, and is faster. So I encourage everyone to utilize this mediation system because it does work. These are the different locations of mediation centers. As you can see, they have telephone numbers. I have provided you with a link, and you can, call them. You can also email them. If if you have any issues, this is the way to go. Faster, parent friendly. Please use it if you need to. Now, impartial hearing, and this is a biggie. First of all, I want to be honest, and I want to say that the impartial hearing system in New York City is broken. We wish it works better, but it doesn't. So if you have any issues that you are requesting an impartial hearing for, most likely it's going to take a long, long time to resolve those issues, and you need to be aware of that. There is no fast tracking in this system. Impartial hearings are like court. You can bring witnesses, you can bring documentation, you can bring anything that is going to support your point. It's similar to a trial. The impartial hearing officer works like a judge. They will hear all the parties and they will make a decision, and you will receive a decision in writing. Now, important here in impartial hearing is a few things. Once you request an impartial hearing, whatever you request an impartial hearing for, that's the only things that are going to be discussed. For example, if you request an impartial hearing and you put 3 bullet points, only those 3 bullet points are the ones that are going to be discussed and decided. You cannot request an impartial hearing and put 3 bullet points, and then the day of the impartial hearing come out with a bag of 10 different things, because the impartial hearing officer could say, wait a minute, I only gonna discuss the 3 things that you request and we apply. If you need 10 things, then you need to apply separately for those 7. That's what they're supposed to do. However, I myself have encountered many occasions in which even though the impartial hearing request was for 3 things, the impartial hearing officers is willing to listen to other issues, but that's not what they're supposed to do. If they do that, it's because, they want to be nice. But if you request an impartial hearing for 3 things, those are the things that are going to be discussed. Very important for impartial hearing is evidence. Once again, evidence is everything. This is not a process in which you will start a sentence like I wish, I want, I feel. That's probably going to get you nowhere. If you believe that things are not working with the current school, they don't have the program, they don't have the services, you just need more of this, less of that, you need to arm yourself with independent evaluations and independent witnesses that are going to support your point. I wish it was different. I wish they could take, I wish, I feel, but they don't. So you need to arm yourself with a lot of documentation to support your point. And the way that you're gonna do that is by recruiting independent evaluators, other people who can actually guide you in what your child needs. And be on point of what those needs are. If you go to a impartial hearing and you said, oh, I feel that my child could benefit from private school, that's gonna get you nowhere, because not every private school is made equal. So you need to point out what is it that is gonna help your child to get an appropriate education that DOE doesn't have, and the non-public school half of the private school have. So you need to be clear. Most of the parents, families, they don't understand that. And they show up waiting months and months and months for impartial hearing. And when that happens, they don't have any evidence supporting their point. So most likely that's gonna go nowhere, because once again, this is like a trial. Impartial hearing office, in order for them to to make a decision, they need to have some proof that what you're saying is really supported. And the burden of proof is on you, the family, the parent. Okay, so once again, that's why you have to arm yourself with a lot of support and documentation to your point. Once something is decided in the hearing, you cannot bring that back. For example, if you wanted more speech therapy for year 21-22 or 2021, if they decide that the decision is against that, you cannot bring the same issue next year because it was already discussed and solved. Once again, be clear about impartial hearings, what they do, be armed with a lot of documentation. This is another process that you don't need an attorney. However, if you have access to one via legal services, legal aid, your lawyers, advocates for children, feel free to recruit one.
And Paola, just to be clear, the decision that's made in an impartial hearing is only for the school year that's been brought to the impartial hearing, correct? It's not, so if it gets stuck in the rut for God knows how long, then maybe your child has already moved on to the next grade, but the decision from last year will be made, and I guess it would be compensatory services and all of that would be...
It will be a standing. Let's say if I request an impartial hearing in 2020, but I didn't get a hearing until 2021 because it was a pandemic, because the school weren't functioning properly or whatever, my decision stands, but still was an issue for 2020. So let's say it was compensatory services in the form of tutoring. That's what I was asking. And the decision is on my favor. Definitely, I could implement that decision in year 21 or 22. However, if the decision is against me, if the officer said, I don't see grounds for compensatory services, you are denied these services of in the year 2020, that's it. You cannot, in 2022, you cannot bring the same issue for year 2020 because that was decided on. Is that clear?
Yes, no. Yes, I just want to make sure that everybody understands that you might not get a hearing for a year. So the next year, whatever resolution is, or whatever the finding is from the hearing officer, it'll be different. It might be different.
Well, it will stand though.
Right.
It will, the decision will stand. If I submit, for example, if I submit my child, the school failed to provide speech therapy for year 2021, and I'm requesting compensatory services for that year, even if the decision is in 2022, it's still as is related to year 2021. However, if I request an impartial hearing in 2022, right, for something that it was denied in 2021, that's not going to stand because that was decided already against you. So you cannot bring the same issue for the same year for something that you were denied already. Got it. That it was decided on. It's like, think about this like going to a trial. Nobody could go to a trial for the same murder twice.
That's a great analogy.
So that's the same thing. Now, keep also in mind that if you're asking for whatever you're asking, usually in the process of impartial hearing, they usually only look at 2 years back. If something happened, and I have this all the time, if your child is in middle school, 7th grade, and you try to request compensatory services because the issue started in kindergarten, you're not gonna get any compensatory services from kindergarten to 7th grade. That's too old. So once again, don't wait too long. If there are things that are not working and there are things that you need to resolve, use mediation or use impartial hearing closest to the issue. Don't wait 3, 4, 5 years, because then the issue is too old already, and your child, on the other hand, have wasted so much time. So keep that in mind. It's time sensitive also. Okay. So once again, I explained this, the impartial hearing officer can only give you what you ask for in the hearing request. Going back to my bullet points, if I requested 3 things that are problematic in my impartial hearing request, that's the only thing that the officer is gonna discuss. The timelines do apply. That's what I was saying. Like if something happened in kindergarten, your child is already in 7th grade, too late, too many years. I also will suggest for you to read a lot about the impartial hearing process itself, just because I mean, and we do have fact sheets, informational papers about impartial hearing process. So that way you understand the process and you will be able to utilize the process the appropriate way. I have information, standard information, extensive information about impartial hearing and about mediation that I could share with you, or you can go to our website and it's posted there. But I will say, before you start even any of these processes, educate yourself about them. The devil is in the details. Okay, what can I request a mediation or impartial hearing? It's also important, once again, this goes to the education part. There are certain things that you will be able to resolve via mediation, and there are others that you're going to be able to resolve only via impartial hearing. So, for example, if you want to discuss a new setting, a new program, new services, mediation, you can utilize mediation for that. Now, if you want to discuss private school payment, then that's only impartial hearing. Usually people who go to mediation from DOE, they don't have the authority to sign on contracts that is going to mean that DOE needs to pay private school $50,000, $60,000, $70,000 for your child to attend. So that needs to, that is an impartial hearing. Sometimes makeup services, if your child didn't receive a speech therapy and you try to recover that time, mediation is a good way if the school is not providing you with what is called the related services order, which the school recognized, yes, we didn't provide you with 20 sessions of partial hearing because I'm sorry, 20 sessions of speech and language, because our speech and language therapy left, you went to have a baby, we couldn't hire anyone, so therefore we know this was our fault, and here's the order for you to get 20 sessions. And sometimes they give you the option, if it's 20 sessions, we can, add them to the ones in school, or they give you a list of providers, independent providers, to cover those 20 sessions. But once again, usually schools do it, they recognize they fail and they do it, but if they don't, then you have mediation. That's something that you can do via mediation. I'm gonna talk about pendency quickly. We don't see much pendency except from preschool to kindergarten. However, what pendency is called stay put, meaning that, for example, if your child is if your child found an IEP, and let's say in that IEP, the team says, we think that your child's current program, services, and school is not appropriate. We believe that the recommendation is District 75. I have people that they rather die than send their kids to District 75. So if you are one of them, there is a process called pendency in which your child could stay in the current placement until something is done. Meaning that at the time that you are offered this 75, you need to trigger pendency via requesting mediation or impartial hearing. That doesn't mean that you're gonna win the case. That means that while you're going through those legal processes, your child is gonna stay in the same school, okay? So that's what pendency means, stay put. They don't want, you don't have to move your child if you're in the process of figuring out what's best for your child, okay? Another note that I want to say about District 75 private schools, at the end, you must think about what is appropriate for your child. There is no magic here. I cannot tell you that private schools are better for every child with a disability, the same way that I cannot tell you that District 75 is the best setting for a child with a disability. It depends. And it depends what works for your child. I have families that put the kids in charter school and now they want to pull them back to District 75. I have families putting their children in private school and realize that that wasn't the best for them and bring them back to community school. So once again, this is not a magic formula. What it is what's gonna work for your child individually. I had cases of twins, and one was needed one placement and the other one needed a totally different placement. Twins with same diagnosis, different needs. So once again, the focus here is what is appropriate for your child. It's not like one system is better than the other, it's what is appropriate. For some kids, yes, especially non-public schools is the way to go. For others, District 75 is the way to go. So once again, don't get yourself into this box that is private school or nothing, because there are very bad private schools out there as well. So once again, what is appropriate is what is gonna work best. So charter schools are public schools. I want for you to know if your child is in a charter school, the Department of Education is still responsible for developing the IEP. If your child needs related services, DOE is still responsible for carrying out the IEP and the related services. So be clear about that. If your child is, the charter school is not providing the services for your child, you still will need to reach out to the Committee on Special Education and complain about what's going on with those services. So I want to be clear about that because a lot of our families are confused about charter school. Now, charter schools, they don't have to accommodate your child's IEP in terms of the class size. For example, if you have an IEP and the IEP says that your child's supposed to be in a class of 12 students, one teacher, and one paraprofessional, and just so happen that your child wins the lottery in one of those charter schools, and you go with your IEP, and the charter school says to you, yes, your child have a seat here, but we don't have 12 one-to-ones here. They don't have to create one. So just keep that in mind, because your child has an IEP that says 12 one-to-one. If the charter school doesn't have that seat, they don't have to create one for your child. Now, what's different about DOE schools is because there are so many of them, it's easier for them to accommodate your child. So let's say your child goes to community school and the IEP changes to 12 one-to-one. That particular community school might not have that class size, but it may be another community school in the same radius that you live that have that class size, so they're able to offer you a different school. But once again, charter schools, they are not obligated to create a classroom specifically for your child because you came in with an IEP that says 12 one-to-one. Now, if they take on your child and they do have, for example, an integrated co-teaching class, and they also, your child also needs speech, occupation, and all that, they have to make sure that those related services are in place, and they need to contact DOE for DOE to provide those services at that setting. And sometimes it gets muggy because if they don't have it there, then that means that your child will receive your services after school and all that. So you need to ask all those questions. You need to ask all those questions. Once again, whoever takes your child with an IEP, either charter or probably they supposed to carry on the IEP, but in the case of charter school, responsible for developing the IEP is DOE, and the responsible for related services also DOE. And sometimes that's challenging because the two of them, sometimes they don't work together and there is a disconnection there. So just keep that in mind. Okay, 504, I'm gonna go quickly in 504. The 504 is a federal anti-discrimination law that applies to any school that takes federal money. So really a 504 plan, many of the kids who have ADHD, they don't need an IEP. Sometimes they just need accommodation, which is a 504. And they will ask, you know, the 504 will spell out accommodations for educational services, testing, extracurricular activities, physical access, discipline, all that is via 504, and those apply to public schools and charter schools. Once again, 504 is different than an IEP. Services such as like a paraprofessional, speech and language, speech therapy, occupational, those are IEP services. Those are not 504 services. So keep in mind the difference between one and the other. Actually, there is a website called understood.org that actually have a table that compares IEP and 504s. Because my parents, sometimes when they call me, they're confused about services that they want under the 504 that are not under 504, they, you know, is more under an IEP. So once again, the more that you educate yourself, the better advocate you can be for your child. So there are major differences between 504 and IEP. Okay, private school placements. This is a biggie here, just because a lot of my families call me straightforward and said, oh, I want private school for my child. So let me once again remind everyone that you and I and anyone who is listening in today, we can place our child in any school that we want. I could pull my child from public school, put it in private school, charter, whatever I want to do with my child is my choice. However, the issue here is that if we want to place our kids in private school, but we're asking DOE to pay for it. So that's when it becomes an issue. The issue is not me placing my child in private school. I could do that at any time. But if I want Department of Education to pay for my child's education, then that's when we enter into a different conversation. Okay. Starting with non-public schools. Non-public schools settings are considered more restrictive environments than public schools. So you have to understand that, because I get parents that tell me, I want my child to be integrated. I want my child to be with other kids, typical kids, but at the same time, they ask for private school. So private schools are not integrated. If you place your child in a private school, every student in that classroom is a student with a disability and most likely a student with an IEP. So the rule of least restrictive is gone. It's more restrictive, okay? And a student is not automatically entitled to private school, even if Department of Education have done something wrong. And let me explain. Sometimes I get calls, oh, the school failed to provide occupational therapy for my child for an entire year. I want private school. If your child didn't receive occupational therapy for an entire year, the remedy for that is DOE to provide those therapies for your child. It's not private school. Because how do we get from not having occupational therapy to entitled to private school? It doesn't work that way. So there are few ways that you can get DOE to pay for your child's private school. One of them is the Nickerson letter. By the way, Nickerson letter is almost non-existent because the Nickerson letter was given not on the basis that your child needed a private school. it was on the more on the basis of technicalities that your child was not offered at school, and therefore you were entitled to a Nickerson letter. Issue with Nickerson letter, a few. One, that you can obtain a Nickerson letter, and if they are not private school with openings, you're just gonna sit with that in your hand. And two, in the process of you finding a placement for your child with a Nickerson letter, if DOE finds you an appropriate placement, that's it. They find you appropriate placement, Nickerson letter, no more. So we have to be clear about that. DOE have gotten really, really good about not providing Nickerson letters, because once again, this is not about the education benefit of your child. It was more about technicality. The other way is deferral to central-based support team. But this means is that your child is in a DOE school, he is not making progress, there's discussions, IEP meetings, nothing have changed. So the IEP team, what is now called the support team, will meet and said, we don't think that is any school in the public system that have what your child needs. Therefore, we're gonna defer your child to CVST. What that means is that they acknowledge that this public school system doesn't have anything appropriate for your child for them to cover FAPE, and therefore they're gonna defer your child to CVST. When the IEP is deferred to CVST, what the process is that you will get a coordinator from that department who's gonna put together a package of information about your child, and he or she is gonna contact different private schools, non-public schools that have actually contracts for payment with DOE to place your child. Now, something that we must keep in mind, DOE have no say in the public school, in the private schools, taking your child. Let's say DOE sends your package to 5 different private schools. They look at your child's information and they determine that your child is not appropriate for the school. There's nothing that DOE could do to make them take your child. And I get those calls too. Parents sometimes visit schools, they fall in love with the school, and the school said, once we don't have seats, or 2, we do have seats, but your student is not appropriate for our program. There is nothing that DOE could do about that. There is nothing that we can do about that. Why is that? Because these are private entities. The only relationship that they have with DOE is payment. So they agree to take DOE students because DOE is gonna pay. But DOE cannot tell them, take this student or open a new classroom for my student, none of that. These are private entities. And we have to be clear about that. Now for non-approved private school, that means for schools that you want to place your child, but DOE doesn't have contracts for payment. That is called Cutter or reimbursement, or Connell's pre-reimbursement. This is a very difficult tax here, because what we're saying, for example, under, I explain all this, under Cutter, we're saying that once you have to give private notification to DOE saying, I decided myself to place a child in this private school, and I'm gonna ask you via hearing to pay for it. So that has nothing to do with DOE. What you're saying is like, I don't think my child was getting an education from DOE, and I decided to place my child in a particular school, and now I'm gonna take DOE to impartial hearing so they could pay for the school. An issue with that is like if you lost the case and your child spent a year in the Cutter school, you're gonna have to pay that school if you lost the case. If you win the case, then DOE will reimburse that school. But once again, you're taking a risk, because all these private schools, they're gonna ask you to sign contracts saying, if you lost the case, you need to pay. Okay, so be aware of that. And then Connors is pre-reimbursement. So Connors works the other way, meaning that you want your child to go to private school, but you cannot afford the cost of tuition and all that. So you do a pre-hearing for that DOE to approve that school. Once again, difficult tasks. I could tell you my office particularly don't do Carter or Connors because the people that we serve are usually people who cannot afford to put a down payment in any of those schools. And therefore, you know, and then they have to wait for impartial hearing. And we also are very conscious and mindful that if you lose in the hearing, they have to pay. So there are a lot of private practitioners that do Carters and Connors. But once again, just FYI, if you lose the hearing, then you have to pay because you sign a contract. This is the end of my presentation. I have, you know, a list of different places, including the impartial hearing office, the superintendent office, community. So this is all resources. We also, like I said, in our own website, we have a lot of information, a lot of fact sheets that you can read with a lot of information. A lot of resources. I also put out a resource guide every Friday. So if you go to our webpage and you look for education resources, every Friday you will see new information about reopening schools or what's going on with schools, you know, different things that are very, very important for you to learn. This is the list of the things that you're gonna find in our website, different topics that you can find there. Once again, we are open remotely. Our intake hours are 10-3. You can call, our telephone number is there, or you can actually fill out a short form, nypl.org, get help right here, and somebody will call you. So at this point, I want to give you tips. Once again, keep record of everything in terms of who you talk to at school, who you asked for a new evaluation. Email is better. Nobody sends anything certified mail anymore. So email is totally appropriate, text, whatever you have. And when you call to request anything from Department of Education, please write the name of the person who you talk to and the date and what you talk about. Because guess what happened? You call me and I ask you, okay, so who told you that you were not entitled to a new IEP? And you will tell me, oh, I don't know. I didn't catch the name. I didn't write it down. So that's a missed opportunity there. Because if I called you in and I said, Margaret, the social worker, told Miss Smith that she wasn't entitled to an IEP, then we're up to something. So we need to keep in mind to keep notes and to keep records, because that's gonna help us. Keep copies of everything. If you have no information about your child that you think is helpful for his education, please share it with DOE. Once again, a lot of families would hold a lot of information about their kids, not knowing that actually that information might help their child. So I want to thank everyone for being here today. I want to definitely thank Synergia for having me today. It has been my pleasure to provide this information today, and open to questions if there are any more.
Thank you so much, Paola. Thank you. That was such a thorough presentation and it's really important. I think navigating special education in New York City is just, it's not just going to the schoolhouse and, you know, who do I talk to? It's a system and it's really complex, and I really appreciate it. I know the parents are already sharing feedback in the chat window about how great your resources that you shared today have been. We do have a few questions right now. Natasha asked if a student can have a 504 and an IEP at the same time.
Some do. However, once again, a lot of the stuff, if that student needs also an IEP, a lot of the stuff covered by the 504 plan is on the IEP. Because the 504 plan sometimes focus more in accommodations, time and a half for testing, extra time, being moved to a room that by themselves. All those things could be integrated on the IEP. I will suggest for you to look at the Understood website and look at the 504 plan versus an IEP and see how they are covered different things, but at the same time, a lot of the accommodations can be fall into an IEP.
Great. And then Mr. Renier was asking, what's a reasonable time frame that you would suggest for parents to ask the DOE for compensatory services dating back to last year?
Well, if this is like a several false question. If you want to request compensatory services because your child didn't receive services, that's one thing. If you want to ask for compensatory services because of the COVID and you believe that your child missed a lot of education and all that, then you can request impartial hearing any time to start that process. But keep in mind, you're probably not gonna get to a decision within this year. It's a backlog in impartial hearing. So if you believe that you should be compensated for last year's education via tutoring, then you can request now. And once that the decision is made, you will get that. I could also tell you that there's several advocates who are working. We are working together to put some kind of plan to expedite those processes, to kind of have, instead of parents going to impartial hearing, to have like a sidetrack to compensate for last year. But once again, that's in the works. That's probably not going to happen anytime soon. But we are working on that because we realize that a lot of kids, every student lost time. But for our kids with disabilities, due to the immense need that they have to for an appropriate education, is that a loss, it sounds bigger. But once again, short answer, if that is your case and you want to request compensatory services in the form of tutoring for last year, you can request impartial hearing any time.
Paula, would you say that it's because of the concerns around education loss for the COVID year, we're all expecting a flood of compensatory service files to be made, claims to be filed? So would you say that the quickest remedy to get ahead of that and not wait until the next year for hearings and what have you, would you advise that the best way to get around that is to have a mediation right now, to file mediation now? Or
mediation, probably, if you are asking for compensatory services in the form of tutoring, mediation is not going to give you that, because once DOE agrees to pay for tutoring, those actually are like pay services, and the person from the DOE who attends mediation probably it's not going to have authority to, for example, approve 200 hours of tutoring services at the cost of $125 if you use Linda Bell or one of those agencies, or Huntington and all that. That's a lot of money. Yeah. So they're not going to have the authority to do that. So usually compensatory services, if you're asking specifically for tutoring from one of those agencies, either EBL, Linda Bell, or Huntington, is impartial hearing. You can file at any time.
Got you. So maybe a mediation for right now would be better for related services then.
Oh, for related service, definitely you can use. But I always also strongly suggest that you start with the school before you do mediation and all that. In every issue that you have, you always have to start with the school. And I get those calls. Sometimes people call us and the first question is like, did you talk to school about this? No, I didn't. Well, sometimes that's the fast track. If the school recognizes that they failed to provide something, they most likely to give you an order and you can start working on that immediately, opposed to recruiting ads and then we have to go through the legal process and all that. That takes time. That takes time. So once again, always start with the school. And it's also good for us to hear. When you come to us, you will tell me, well, I talked to the principal, he did nothing. I talked to the psychologist, she did nothing. So now we know that you try and nothing happened. So therefore, we now, move forward in that way. Always start with the school because they can resolve many, many, many things.
And to what Paola was suggesting earlier in her tip section, that's why it's so critical to document and keep a notebook of all of these interactions that you have with the school, any school official. It could be your child's teacher or their therapist or the counselor, like school psychologist or principal, or even, what was it? The parent liaison, slips my mind. But yes, just
parent coordinator.
Parent coordinator, thank you, there it is. But yes, always document that information because it just shows what you're doing. And, if just try to have the connection, and if it's not helping, just remember somebody always has a boss. Everybody has a boss. Ms. Gonzalez here was asking, can a school dual enroll a student in similar classes? For example, AP English and general ELA and provide ICT?
I'm confused about that question. I mean, if your student if it's an integrating co-teaching, that means that there's two teachers at the classroom, right? So that's the setting. And your child could take any of the classes that they need to, if they, if that's part of their curriculum. So I'm not sure about this question.
Ms. Gonzalez, if you maybe want to ask your question in a different way in the chat. Not sure. I see you're still with us. We have another thank you. Greatly appreciated this presentation. Well, we will wait for another question, but just in case, yes, we will share this presentation with you and Paola's presentation with all the links and tips that you can access and look on. You can always look at her website, which we will include in the follow-up email, which will include her contact information as well, in case you need to reach out to our partners there. And if you ever need to speak with a special education specialist, every Friday at Synergia, we always have from 1 to 2, an hour where you can speak to an education specialist one-on-one live and ask specific questions that you may be encountering at the moment. That's a lot quicker than going through an intake process, at least in our office. I won't speak for Paola's, but yes. But if you do want to take advantage of the intake, just please allot like 15 to 20 minutes so that we can ask all these questions, because we want to make sure that we're giving you all of the assistance that you can benefit from, no matter if it's the New York lawyers or Synergia. We just want to make sure that you're fully supported in every way. Ms. Gonzalez was saying ICT was being provided in AP English, but the school decided to no longer provide it and instead enrolled in both ELA 12 and AP English to provide ICT. Does this violate a least restrictive environment?
I'm not sure. I will suggest that Ms. Gonzalez perhaps call my office so we can unfold all the information, because I'm still not clear what the school decided, what we mean by school decided. If you were in disagreement with our WhatsApp services that they they weren't able to provide any more, and you want, I mean, so many variables on this. Was as a service that they say, we don't have that service anymore. Either you need to move out your student, or if you want to keep your student here, this is what we're offering now. So it's more questions than answers. So I'll be happy to, I will suggest for you to either, I don't know if you want to call senior here for the, 1 to 2 to see if they could get you, or you can call your lawyers directly or fill out the form. So somebody will call you and actually ask all the appropriate questions in order for us to give you the appropriate answer.
Yeah, go ahead and contact either one of us, Ms. Gonzalez. Our information will be in the email, in the follow-up email. We thank you for your question. So lastly, I just want to make a quick announcement. Paola will be with us next week on Tuesday, same time, same place. And she will be discussing future planning. So looking at what a future holds for a person with a disability requires thoughtful pre-planning. And so Paola will be here to provide essential tools to successfully understand the special needs and trust supplement needs trust, a healthcare proxy, what is a letter of intent, what is a power of attorney, what is supported decision-making and or guardianship, and many other things there. Some questions that you might be able to answer after we have this presentation will be like, do you know how to plan for the future of your family member with disabilities? Or do you know how to preserve government benefits such as Medicaid and Social Security Disability Insurance, or SSI, while saving money for your family member with a disability? So I'll include the flyer for that, but that'll be next Tuesday at 10:30 again. So yes, so thank you, Paola, and thank you everybody who's been here. We really appreciate it. I will go ahead and activate the poll for any last surveys, and please, we thank you for being here. And if you have anybody that would benefit from this that speaks Spanish, on Thursday, we will have the same presentation all in Spanish, and same thing for next week's presentation as well. So thank you so much and enjoy the rest of your day. I will.
Thank you. Have a good day, everyone. Thanks, JC, for having me.
Yes,
Bye.
absolutely. And the poll is live.